Good afternoon, everyone, and thank you for joining us for part 4 of our webinar series. If you've missed any of the previous 3 presentations by Attorney Atty Lantz on how to protect your assets from the nursing home, please visit our website, lantzlawinc.com. You can click on blogs, and you can watch any of our past webinars there. So today I'll be finishing up the series with information about the basic documents that we think everyone should have. First, I'll introduce myself. My name is Michael Coleman. I'm an attorney here at Lantz Law. I've been here for about 6 years now. I got my JD from Hofstra School of Law. I'm a member of both the National Academy of Elder Law Attorneys, as well as a Massachusetts chapter of NALA, as well as the American Academy of Estate Planning Attorneys. I am admitted to practice in both Massachusetts and New York, and I have about 11 years of experience. On a personal note, I like to spend time with my dog Logan, who you can see down there on the slide there. We like to go for hikes in the woods and play with the ball and all that fun stuff. I'm also going to introduce you today to Atty Lantz if you haven't seen her on any of these webinars before. She has her BA in Geography from Clark University and her JD from UMass Law School. She's also a member of the American Academy of Estate Planning Attorneys and NALA and Mass NALA that I mentioned before. She is a certified veteran specialist. She's a licensed insurance broker in Massachusetts and Florida. She is a licensed real estate broker in Mass and Rhode Island and a licensed mortgage broker here in Massachusetts. And Tenny likes to spend her free time with her husband, Ray, and she has 5 beautiful grandchildren. She also sings in the choir at the church. If you haven't done so already, please visit our website. That's lantzlawinc.com. If you do that, you can download free reports and articles. You can find out about top 10 estate planning techniques, learn more about me and Tenny and our staff. If you'd like to provide your email address, you can do that for ongoing estate planning updates. And you can also learn more about upcoming workshops that we're doing in your area, potentially. And if you're on Facebook or Twitter, you can like us on Facebook or follow us on Twitter, so please do that. As I mentioned before, we are members of the American Academy of Estate Planning Attorneys. We're a founding member of that organization. We've been members now for 27 years, and it provides us with continuing legal education. We have access to other attorneys throughout the country in case we need something done somewhere else. So it's a great organization to be a part of. We're also members of NALA and the Massachusetts chapter. Again, that's something that provides us with updates on the law, continuing education about what's going on in the law. And again, we have access to attorneys throughout Massachusetts and throughout the country in case we need assistance from any of them. So as I mentioned, today I'm going to talk about basic estate planning information. So what documents we think are most important for everyone to have. So we think that trusts and or wills are really important to have. I'm going to talk about both of those today. The durable power of attorney for property, and then certain healthcare documents that I'm going to talk about. And if you'd like to discuss any of this with us, you can always give us a call. Today, our phone number here is 508-998-8800. We do offer free estate planning consultations, so if any of the things that I talk about today you want to discuss in more detail, please feel free to give us a call. So first, we're going to talk about a will. What does a will do? What we like to say is basically it just gets you into the probate court. There are a few very important things that a will does. First of all, it names your executor or the personal representative here in Massachusetts. It also names your beneficiaries. So those are the people that will inherit your assets. But a lot of people think that a will, if you have a will, there's no court involvement. That's not true. If you own assets in your name alone, even if you have a will, there's still going to be a probate. So if there's a single person with assets in their name alone and they pass away, there's no owner on those assets. Someone has to go to the probate court and be appointed the executor of the estate in order to do anything with those assets. Same thing with a married couple. If there's a married couple who own property jointly and they both passed away and there's no ownership of that property, the will still has to be submitted to the probate court in order to appoint an executor of the estate to then transfer or sell assets. So as I mentioned, a will does a few very important things. It names your personal representative. So again, this is the person that's going to be in charge of your estate and who gets what and how the assets are distributed to the beneficiaries. And then it names beneficiaries to inherit everything. So this would prevent, laughing heirs, like we like to say, people who weren't involved in your life all of a sudden are benefiting and inheriting assets that you may not want them to get. So when you have a will, it's very important to designate who your beneficiaries are and how they receive everything. But there are some disadvantages of having just a will. As I mentioned, if you own assets in your name alone and you pass away, or if you're a married couple and you've both passed away and there are assets that were held jointly, those are now probate assets. So you do have to file the will with the probate court. It can be an expensive process depending on what the assets are. So if we're talking about real estate, we're always going to do what's called a formal probate here in Massachusetts, and that's a relatively expensive and time-consuming process, and nothing can be done with that asset until the probate court appoints a personal representative. That can take some time. It is a public process, so anyone, once the will is filed, anyone can go to the court and look at the will and see who the beneficiaries are and see who the executor is. If you own property in multiple states, say you have a house in Massachusetts and maybe a condominium in Florida or a vacation home in New Hampshire or whatever the case may be, you may have to do a probate here in Massachusetts and then do an ancillary probate in the secondary state. So you may be looking at multiple probates. And again, this is if you own assets in your name alone or they're jointly held with a married couple and they both passed away. So now that I've explained sort of the benefits and the disadvantages of having a will, I'm going to talk about what the better alternative is. And we think that in many cases, the better alternative is having a living trust. So what is the benefit of a trust? When you set up a living trust, after you set it up, you then transfer your assets into the trust. So for instance, if you're a single person and you have bank accounts in your name alone, once you set up the trust, the bank accounts will be retitled into the name of the trust. You would be the trustee. So you continue to control all the assets in the trust, the bank accounts, the money in the bank, real estate. If you want to buy or sell, you continue to do that. And then you name what are called successor trustees in the trust. And these are the people that would take over managing those assets for your beneficiaries if something were to happen to you. So the reason that these assets would now not go through probate is that the trust is basically the owner of the asset. You're the trustee, so you're the one who controls it while you're alive. And then when you pass away, the trust continues to own the property and the successor trustees are almost immediately in control of those assets. So there's no probate for any of the assets in the trust. There's also an estate tax benefit here in Massachusetts. If you own property and you're a single person and your estate is over $1 million, and this includes real estate, life insurance, retirement accounts, bank accounts, all of your assets. If that's over $1 million, you have a taxable estate in Massachusetts. And if you're a married couple with assets over $2 million, you then have a taxable estate when the second spouse passes away. So if you set up a trust, there are certain things that you can do within the trust to minimize or eliminate the estate tax here in Massachusetts. And that's another very big benefit of having a trust. So who is involved in setting up a trust? First of all, there's a trustor. This is like the grantor of property. The trustor sets up the trust, creates the trust. So if you're the one creating the trust, you're the trustor. Then there's a trustee. And if you are setting up the trust and it's your own trust, you would be the trustee. So you would be both the trustor and the trustee. And then you would also be the beneficiary while you're alive. Then you would name secondary or remainder beneficiaries after you've passed away. But if you are setting the trust, you're in all three of these positions while you're alive. You're the trustor, you're the trustee, and you're the beneficiary. So that's the will and the trust. Another important document that we think everyone should have is the durable power of attorney. This is a document that would come into play if you are alive but incapacitated and unable to pay your own bills or make your own decisions. The durable power of attorney agent would do that for you. So say, for instance, you're alive and you're in the hospital and for some reason can't pay your bills or access your bank accounts, the agent and the power of attorney could do that for you. So many times it's either a spouse or a child who would step into that role and act on your behalf. Now, the reason that this is so important is that if you or someone you know is incapacitated and they don't have a durable power of attorney in place, then we're looking at what's called living probate and conservatorship. So this is a situation where someone would have to go to the probate court. They would have to petition the probate court to be appointed conservator. And this, again, the probate court is a public process. Anyone could go in there and contest. If someone else wanted to be conservator, they can contest your petition. So if you have the durable power of attorney in place, you avoid the probate court, the living probate process. And then we think that there are certain healthcare documents that everyone should have. So there's a healthcare power of attorney. This is a document that names an agent to make healthcare decisions. So again, if someone is incapacitated and can't make their own decisions, the agent and the power of attorney would be able to do that for them. So this is an important document, again, because this would help to avoid a living probate and a guardianship process. So again, if you're in the hospital and you can't speak to your doctors and you can't express your own wishes, if you have an agent named in a healthcare proxy, healthcare power of attorney, that person would do that for you. If you don't, someone's going to have to petition the probate court to be appointed your guardian. And again, this is a public process. It can take some time. And if you're incapacitated and someone needs to make healthcare decisions for you, you don't want there to be a big delay. So if you have a healthcare proxy in place, that would avoid the probate. And again, what I said before is that if you don't have the durable power of attorney and the healthcare power of attorney in place, you're looking at a potential conservatorship and a guardianship, and those can be avoided with those documents. Living probate, again, it's filing potentially 2 petitions, one for a conservatorship, one for a guardianship. You're paying 2 court fees for filing those petitions. If you have attorneys involved, you're paying attorneys' fees. And the bottom line is that that can be all avoided if you have the durable power of attorney and the healthcare power of attorney in place. If you're worried about protecting your family and your assets from the nursing home, you can make an appointment for a consultation. Our consultations are free. If we're talking about immediate need of asset protection, meaning someone's going into the nursing home very soon, and you need to talk about how to protect those assets, those are billable appointments. But if you're talking about estate planning in general, setting up a trust, setting up a will, getting a durable power of attorney or healthcare documents in place, those are free consultations. Whatever you do, we ask that you don't just put your head in the sand like this person. Don't let this happen to you. We don't want to see you get into a situation or someone else that you know be in a situation where something happens and you don't have the right documents in place. So it is important. It is a free consult. So give us a call. Again, the phone number is 508-998-8800. Or if you want to visit the website, that's lantzlawinc.com. As I mentioned, if you're worried about your assets or someone's assets that you know going to a nursing home, we can help you potentially protect your assets and your family. But please take some action, give us a call. We can sit down and talk about things. And remember, be nice to your kids because they're the ones that are going to choose your nursing home if that were to happen to you. So be nice to the kids. And be nice to your attorney. She'll show you how to protect your assets. Atty. Lantz is the one that does most of the nursing home asset protection consults. So she'll show you how to protect your assets from the nursing home. Thank you for attending the workshop. If you've ever been into the office before, you may have met Luna and Willow. There are office mascots, and they're here almost every day. So if you do come into the office, then in future you'll meet either Luna or Willow, and they're both rescue dogs. I'm very happy to be here with us. Those are Pete Lantz's 2 dogs. Thank you again for attending the seminar. Again, our phone number is 508-998-8800. If you want to set up a consultation and talk more about what we talked about today, again, it's lantzlawinc.com if you want to learn more about who we are and what we do. Thank you very much for attending today.